Welcome to Immigration Quicktake. This is Jessica Eyes with the American Immigration Lawyers Association. There has been concern and frustration within the AILA community regarding rulings on L-1B petitions, a visa category for multinational companies. Here to discuss this critical issue is AILA President Doug Stump, joining us on Skype from Oklahoma City. What problems are being experienced with the adjudications of L-1B petitions?
In 2012, the Chamber of Commerce convened a meeting of the executives from about a dozen or so blue chip, name brand, Fortune 500 companies and U.S. CIS leaders to explain how the change in interpretation of specialized knowledge by U.S. CIS was having a harmful impact on these major employers and players in the U.S. economy. About the same time, AILA submitted a memorandum to U.S. CIS Director Mayorkas, outlining the issues with the U.S. CIS interpretation and how the U.S. CIS interpretation ignores and deviates from congressional intent and meaning. Unfortunately, there's been no meaningful change in the way U.S. CIS and the Department of State for blanket L-1 visa applications at conflict abroad interpret this law. They continue to apply the narrow and, in my opinion, unlawful interpretation and harm U.S. companies and foreign companies wanting to do business in the U.S. by making it hard for them to bring in specialists to perform duties that help the companies compete and to serve the needs of customers in the U.S. and to grow the U.S. economy.
What needs to be done to resolve this issue?
Jessica, we'll continue the dialogue with USCIS on this issue, but we also want to consider all of our options, including litigation. We need to confront the reality of the service position. Resistance has been strong, even overwhelming, making our discussions more than a little repetitive without moving the needle a bit. The recent DHS OIG report on L-1B adjudications is one of the examples of the resistance that we see within the agency. We believe that if this issue is submitted to a federal district court, the judge will order the U.S. CIS to adjudicate petitions based upon the statutory language and not the restrictive interpretation that is based upon the pre-1990 standard. Thus, we need to seriously consider litigation. The first step to assess our alternatives is to compile a more complete sample of adjudications. AILA would like all members who work in the L-1B field and who have had good cases denied, particularly recently, to send those case examples to reports@aila.org. We are looking seriously at litigation, but to do a thorough evaluation, we need examples. We are working closely with the American Immigration Council on this project and are reaching out to our allied organizations for support. But we need you and your clients to help us identify these case examples.
Doug, can you give us a rundown on the background of L-1B visas?
Jessica, the L-1B visa category is for individuals who work for multinational companies in positions requiring specialized knowledge. The visa category was first established in 1970, and at the time, Congress didn't define what they meant by specialized knowledge. By 1990, Legacy INS had developed a definition that was pretty narrow and restrictive, saying that specialized knowledge had to be narrowly held, advanced, or proprietary in nature. The definition was just too restrictive, and in 1990, Congress stepped in and enacted a statutory definition of the term specialized knowledge, saying that a person had specialized knowledge if the individual has special knowledge of the company product, its application in international markets, or has an advanced knowledge of the process and procedures of the company.
Thank you, Doug. And what happened next?
Well, between 1991 and about 2008, Legacy INS and then U.S. CIS pretty much followed that definition and the interpretive guidance by Acting Executive Commissioner James Kulo and Service Center Head Fuji Ohata. In 2008, a change took over U.S. CIS adjudications as U.S. CIS began to import the old doctrines back into the definition of specialized knowledge. And as such, the agency would not approve these cases unless you could demonstrate that the knowledge was highly developed, essential, narrowly held, or related to proprietary interests of the company. The new interpretations basically ignored the changes in the law Congress had enacted in 1990, and it restored the old restrictive interpretation that the 1990 amendments had overturned.
Thank you, Doug, for joining us to discuss this important matter. Again, please send your case examples to reports@aila.org. Thank you in advance for your collaboration in resolving this issue and for watching Immigration Quicktake through the American Immigration Lawyers Association.